The first protection the president enjoys is this protection from being forced to disclose information under certain circumstances. And there's a presumptive privilege not to, except that you should note that the court has never decided whether or under what circumstances the president could be forced to furnish information to Congress. We do have a presumptive privilege. If the circumstances are right, we say can be overcome, but the case that settled that was in the context of a criminal prosecution. Now, the other protection that the president has is an immunity from private suits for damages for anybody suing the president for acts that the president has taken within the broad scope of what the court has described as the president's duties or even the outer perimeters of his duties or his authority. There's a case, Nixon versus Fitzgerald, that establishes this proposition. There, a government employee sued the president for damages because, as it turns out, this employee testified before Congress about some cost overruns in the military. And apparently when the president heard about this, he was basically angry and was sufficiently angry that he told his aides to fire the guy. And the firing that he ordered was contrary to civil service laws. So Fitzgerald wanted to sue and get damages from the president for this illegal act. But the case, having gone all the way up to the Supreme Court on a theory that he could sue, or whether he could sue, the Supreme Court settled it and announced an absolute immunity from private civil suits for damages for any acts that the president takes as president. And the theory was that the president has to have this immunity in order to preserve his ability to act as president. Otherwise, if the president were subject to suits all the time for things he did as president, the president would potentially bear an intolerable burden and could not proceed with the functions of the office. And anyway, at least for the majority, although the court is quite divided on this, it didn't mean that the president was above the law, because there was, after all, impeachment and elections. So the court created this absolute immunity. Now note here what's not covered by absolute immunity. We're not talking about criminal actions, and we're not talking about actions for injunctive or declaratory relief against what the president has done or is doing. We're talking only about civil actions for damages against the president. And we're not talking about protecting the president for any acts the president takes after leaving office. And, curiously enough, we're also not talking about any immunity for the president against suit for acts he took prior to assuming the office. Now, this is presents some matter of interest to us currently, because as you may know, the Supreme Court has agreed to hear President Clinton's claim that the sexual harassment case brought against him by Paula Jones should not proceed while he is in office. Now, Miss Jones alleges that Clinton, before he was president, while he was governor of Arkansas, sexually harassed her while she was a state employee. Clinton's lawyers say that the president should not be distracted by any civil lawsuits, except, in an extreme or emergency or compelling kind of a case, while in office, because the president will be taken up with all of these aspects of a suit, and it will be too much of an interference with the president's duties. So we won't know about whether the protection extends to acts that the president committed before being president to protect the president from civil suits while in office. The case, Clinton versus Jones, will be decided by the court in its 96-97 term. Now, those are the two protections the president gets. The president gets a presumptive protection against the disclosure of information, which can be overcome, and the president gets an absolute immunity from private civil suits for damages for acts taken while president. Now that covers the powers of the president and the protections of the president's office, and we will now switch to the powers of Congress. To begin our discussion of congressional powers, I want to first set out the theory of federal powers. Remember The federal government is a government of enumerated powers. Acts by the federal government, including Congress, must be authorized by the Constitution. Now, this contrasts with the situation of state governments whose powers existed before the Constitution was adopted. State governments have a general power to act for the health, safety, welfare, and morals of their citizens. This power is known as a police power, this general power to act for the citizens' welfare. Congress does not have a police power. Rather, you have to trace back the exercise of all congressional action, as I said, to some authority conferred by the enumerated powers in the Constitution. The primary source of congressional power in the Constitution is Article 1, but there are many other sources of congressional power scattered throughout the Constitution. Now, before we start looking at some of these, and before we begin to think that Congress's powers are very scanty or limited, although we have to trace back Congress's power to authorization in the Constitution, you should recognize that, as a matter of fact, Congress's enumerated powers have been interpreted very broadly, both in and of themselves and with the aid of the necessary and proper clause. In this regard, you probably remember the case of McCulloch versus Maryland. At issue in that case was the constitutionality of Congress creating a national bank, the successors to which are the Federal Reserve System that we have now. But there was no enumerated power in the Constitution that specifically said Congress could create a national bank. Nevertheless, that exercise of authority was upheld by the court in McCulloch versus Maryland on the theory that Congress does have various enumerated fiscal powers, like the power to tax, the power to spend, the power to coin money. And Congress could conclude that having a bank, a federal bank, was a nice instrument, was necessary and proper, was useful or helpful as a device in carrying out Congress's fiscal powers. So, Congress may exercise not only its enumerated powers, but it may also do all things necessary and proper, that is, useful and convenient, to carry out its enumerated powers. Now, as I said, Congress has many powers scattered throughout the Constitution, chiefly in Article 1, power to regulate commerce, power to tax, power to declare war, control federal property, for example, power over bankruptcy. Congress also has powers under the 13th, 14th, and 15th Amendments to pass civil rights statutes. Now, necessarily, we can't look at all of these powers, and so we'll selectively look at two very prominent and important powers, but we've already seen some of the other congressional powers in looking at the powers that Congress has over the courts, over jurisdiction, in looking with respect to the president and the interrelationship of the president and Congress, at Congress's power to limit the president's ability to appoint and remove officials, or the congressional power to declare war, as I've mentioned. We've already seen some of that, but now we want to focus on Congress's power particularly, and we will look at Commerce Clause power and the power to spend for the general welfare. We start with the Commerce Clause. First, we'll identify the general standard that the court uses in this area to judge whether congressional acts are properly within the commerce power. Then we'll consider some examples, and you'll see how broadly this power is interpreted. And finally, we'll identify some important limitations on the commerce power, including the most recent limitation set out by the Supreme Court in the case of United States versus Lopez. Okay. Under Article 1, Section 8, Congress has the power to regulate commerce with foreign nations, among the states, and with Indian tribes. And in terms of the domestic power to regulate commerce among the states, the modern test is that Congress can regulate not only obvious interstate commercial activities, such as regulating the channels of commerce or the instrumentalities of commerce, for example, regulating people or goods moving across state lines, or the use of interstate facilities, like the mail or the phone system. Not only can Congress regulate all of that,